Hello, I guess we're ready to get going on our next panel, which is of great interest to me. It's about charities and their role or the possible misuse of them in terrorist financing, with, I guess, an emphasis here on Special Recommendation 8. I will briefly introduce our speakers here. You all have the bios, so I'm not going to go into detail. From the far end of the table, we have Richard Barrett, who since 2004 has been coordinator of analytical support and sanctions monitoring team of the Security Council Committee for Al-Qaida and the Taliban for the United Nations. Coming this way, we have Alyson King, member of the sanctions team of the External Relations Directorate-General of the European Commissioner and an assistant legal advisor in the United Kingdom's Foreign Ministry. Bruce Zagaris is the next one in here, who is a partner at Berliner, Corcoran, and Rowe, has been there since 1978, serves as a consultant counsel and lobbyist for a number of governments, and is an adjunct fellow at the Center for Strategic and International Studies. And finally, right here, we have Stuart Yikona, a financial sector specialist for the World Bank. All of our speakers have a wealth of experience in a variety of capacities dealing with finance and finance of terrorism and measures against them, and particularly in the area of the misuse of charitable organizations to direct financing towards terrorists. I'm looking forward to hearing what you have to say, and they'll just go down the row here, speak for a little while, then we'll open for questions. Thank you.
Thank you very much, Christina. I think it's Christina.
Laura Chisolm.
Laura,
yes,
Laura Chisolm. Sorry about that. Thank you to Richard and the law school for the invitation. A quick story: when I went to Korea about 6 years ago, when I arrived for about a week, I used to work for the IMF at that time. At the end of the week, one of the Korean ladies said, "I have a confession to make. When your name was sent to us as an advance to prepare for your mission, we thought you were from Japan. But alas, when you arrived, we say, wow, you must be a different type of Japanese species." But who knows? Yikona does definitely sound like Japanese. Maybe my forefathers did come from there. But thank you so much. What I'll do quickly in the next several minutes is just to speak to the slides, and I'll also just speak in my personal capacity. My boss, the program director, I think you have seen the name there, Latifa Chiong, was supposed to be here, but she couldn't. We are having our spring meetings for the World Bank and the IMF, so she couldn't make it, and so I was sent on her behalf. So all the success will be hers, and any failures attribute them to me. Then I can keep my job. But what I'll be speaking about will be from my own personal experience from the work we have been doing, particularly with the developing countries. And for me, that's the prism that whatever I speak about or respond to is through that prism, not from the prism of North America or Western countries in terms of those that export the finances to help NPOs in developing countries, but looking at it from that perspective. But secondly, also from the perspective of my own personal experience, both before I came to the US, getting involved in community activism within my own small town, and also presently involved in an NGO, American 501c registered NGO, which is working in my own home country to build libraries for orphans and vulnerable children. So I'm wearing several hats. The only hat which I think I'm not wearing closely is that of the World Bank, because I want to keep my job if I say anything that is outside the reservation. What I'll do is just speak to some of the issues, just to throw them out there for us to exchange views on. I'll briefly highlight one or two things about the overview of the non-profit sector. What are we talking about? What is the size? then the issues that have been highlighted by Laura in terms of what is Special Recommendation 7 talking about in terms of protection from abuse, and also emphasizing the oversight of the NPO sector, and then the international efforts, the whole issue of raising and dispersing of funds. What are the issues out there and the challenges? And then just highlighting something that I just discovered recently when I was preparing to come here, issues of compliance with Special Recommendation 8. What is happening out there? Because as we know right now, when the FATF promulgates these standards, previously it was restricted to the 32, 33 plus countries, but now it's a worldwide thing. So any standard that's promulgated by FATF is frankly speaking, binding on all countries in the world, because the UN has recognized them. And as Nikos, I think, mentioned, in the International Convention Against Corruption, they have been given recognition. And of course, we have the special recommendation, UN Security Council resolutions 1373, which again also gives recognition to the FATF. So just to get a sense of what is happening. In terms of what we are talking about, and I got this information from the Johns Hopkins University study on civil society. We are basically looking at private philanthropic organizations that are operating on a non-commercial basis. And most of them, in fact, a significant majority in countries around the world, whether developed or developing, they are not part of government. And also, because they are not profit-making, theirs is to help the communities, is to help citizens, is to help vulnerable, if you want, citizens in any jurisdiction. And we are looking at trade unions, we are looking at professional associations, we are looking at political parties. It's interesting when you look at the NPOs, in terms of its broader definition, it includes political parties, but when you look at the Special Recommendation 8 of the FATF, they seem not to include political parties. So that's one issue if you are looking at Special Recommendation 8, which I would want to indicate. Of course, you're looking at churches and mosques and other religious organizations, but also you're looking at social clubs, hospitals, schools. In other words, it's a broad spectrum of entities. But two things which I think the Johns Hopkins University identify, which I appreciate and I highlight, that is, one, you are looking at a sector that has a lot of formality to it. In other words, a lot of them are required to be registered for purposes of tax exemptions. But that does not in itself mean that all of them are formal. A number also are informal. In other words, it's a voluntary. Some of the activities I engaged in before coming here were NGOs without us going to register with the Registrar of Societies, but will be considered. Certainly looking at the standards now, one would say we were operating in violation of maybe the laws of our country. But the other thing is self-governing, and I think this is one area where most of the NPO sectors around the world, especially in the light of these standards that are coming up, that's the resistance. They don't want to somebody to come and regulate them. They are really self-governing. They want to self-police themselves, and that's one issue that I'll highlight later on. In terms of the finances, this is one area where, in terms of my study, looking at this subject, studying it, researching it, but also interaction with governments, which was fascinating, because when you think of the special recommendation, particularly after 9/11 and with the interpretative note that FATF issued in 2006, the impression was that there was a lot of illegal funding in a significant way running through the NPO sector. But the interesting thing is that most of their monies are raised from either fees or from governments. And particularly from a developing country perspective, most of the monies actually comes from bilateral partners to some of the developing countries. The governments, say the US gives to the U.S. International Aid Development Agency, which funnels its money to some NPO in the U.S., which then supports an NPO in a foreign jurisdiction. So you have that fascination that the bulk of the monies that some of these NGOs receive comes actually from not only governments abroad, but even from their own internal resources in terms of channeling through the budgetary allocation when the government presents its budget. Then you have about 12% of the monies that comes from philanthropy, gifts, or donations. Again, most of this information is from the John Hopkins study on civil society. I mention this because there is that impression, I keep hammering on this, that it's not clear what percentage of the funding that most NPOs receive is actually from illegal activities. We have heard this morning there was an indication of some of the resources that are used in particularly conflict-afflicted jurisdictions where monies can be funneled through NGOs. But as to whether that is an endemic thing, is it a prevalent thing, I think the jury is still out there. That's the way I would put it, albeit mildly. But I think it's still a debatable issue, especially when you interact with some of the NPOs that we interview and discuss these issues with. And in terms of the significance, and this is where a lot of NPOs, particularly those who are in the developed countries, had issues with regard to special recommendation aid, is because of the kind of work that they do in most of the developing countries. The gap that they try to meet, particularly when you are looking at most governments now that are trying to become, if you want, fiscally responsible. I'm not talking of the US, I'm talking of countries that have had to adopt a lot of IMF structural adjustment policies where they have had to cut spending on a lot of social issues. They have had to turn to NPOs to fill in that particular gap. And those are the figures that are here on this slide. You have the UNDP talking of 250 million people being reached. The OECD statistics indicate that $12 billion US dollars annually is spent, and most of it is to step into the gap that the government is not meeting with regard to issues of AIDS prevention, with regard to rural development and environmental conservation. One of the things I would want to highlight, for example, certainly from the US perspective, I think we all know about I think it's being considered to be one of the most successful US federal program, the global AIDS monies that I think the Bush administration has given certainly to Africa. Most of that money has been channeled through NGOs. It's not through the governments, but it's through the NGO sector. And perhaps that could explain why it has had a great impact, because they have cut off some of the governments that frankly speaking, are not accountable, put it mildly, and not transparent in the way they carry out their activities. But again, we are looking at a sector that is very significant, a sector that is doing a lot of good. This is what I mentioned about the state and market failure and filling in the gap. In terms of the issues that I would want to throw out there is, again, a challenge. Do we really know the extent of terrorist abuse? I know there are cases that are out there, particularly, putting aside the Hamas, the Hezbollahs of this world with regard to their political affiliations and wings, or putting aside Al-Qaida, putting aside maybe the LTTE from Sri Lanka. It's difficult to say, okay, what are we looking at in terms of the NPO sector? Whether it's by percentage or by actual empirical data of saying in whether it's in Africa, whether it's in Asia, or whether it's in Central or South America, what are we looking at? Can we really say there is rampant abuse of the sector for terrorist purposes? At least what we know from a number of studies and speaking to practitioners is that yes, there is a problem with regards to governance issues. There is a problem with regards to transparency and accountability issues. There is an issue of fraud, embezzlement, mismanagement. But in terms of terrorist financing, a lot of countries that certainly we deal with and we go and assess to find out whether or not they are complying with these international standards. That's one of the challenges that we find. Some countries, for example, where I've been, they have had no history, both domestic or international, with regards to terrorism. They have been at peace for as long as we remember, whether under colonial rule or even after independence. And so in other words, they don't really have this appreciation of how can the sector be used for terrorist purposes. They know they're in a global environment, but in terms of bringing it home, because that's what we want. We want them to comply with international standards. So that I think is what some of us are hearing. Give us the evidence to say, yes, we are vulnerable to terrorism. And I think that's an issue for debate, particularly for us who are in the World Bank, where we even have a unit that deals with civil society. It can be a bit of a challenge and something of great debate. The other issue, I think, which the standards look at is the whole issue of oversight. The question really is, should the government regulate the NPO sector? Or should they be self-regulated? I think one could say, I may be wrong here, but I think outside the US and the UK, there are very few countries that have for the US it's through the IRS 501c exemptions. For the UK, they have the Charity Commission, they have the licensing and registration. But most countries, all they do is register the NPO and that's it. You are on your own, so to speak. But increasingly, not necessarily because of pressure with regard to terrorism, but because of issues of governance and transparency. Most of the NPO organizations have been looking at how they can regulate themselves. They are also weary of the government coming in, again, because they are always in this adversarial position of where they want to look out on what the government is doing. And so you have that issue out there as to how do you monitor the NPO sector. In terms of the international efforts, the other issues, I think I'll ask Richard if you want to have access to this to these slides. The other issue I think which is critical is how do you monitor NPOs with regard to the raising and disbursing of funds for charitable purposes. The special recommendation, I think again because of the debate that was there, the NPOs were saying we don't want you to start to interfere and to regulate and the costs will go up. We are doing a noble thing in terms of helping those that are vulnerable in society. The compromise that was reached with regard to the interpretative note was that the special recommendation would only apply to NPOs that have significant portions of the financial resources under their control in the sector. This again was because of pressure from NPOs in Western countries, because of the work that they do. But secondly, that it has a substantial share of the sector's international activities. Again, that was to take care of the fact that some of the NGOs that are recipients of monies from what are referred to as northern NGOs or NGOs from Western countries, they funnel their money domestically through some of these NGOs, which are very small. They are really not significant when you're looking at the total share of the NGO sector in these countries that are recipients of these monies. And because of that, this was the compromise. But I think the challenge here again, I was looking at I think the last quarter of 2007 in the UK from the Charity Commission, out of 190,000 registered charities, only 600 plus NGOs are worth more than 200 or a million pounds. The rest are very small NGOs. So I think those are the issues in terms of when the standards say you need to monitor them, how do you do it? Even when it comes to the significant ones, it's difficult to see how you can then call upon smaller countries. Again, it goes back to the whole issue of capacity, the one we were talking about. Do they really have the capacity to deal with that, or are they really concerned about the financial institutions? Because that's closer, that's economic. NGOs are looked at most likely as allies, as opposed to banks that charge high interest rates. I mean, that's a political thing, but that's really the thing. But the most difficult one, in my view, is the whole issue of checking the identity and credentials of those that are beneficiaries of those NPOs. How do you do that? For instance, the NGO I'm involved in, we are building libraries in my home country. And the people who will be recipients of our libraries we are building are those who are street kids, they are orphans, and generally the poor people. How are we supposed to identify them as a director in this NGO? What am I supposed to do? I mean, that's a question which is out there. Finally, in terms of compliance, out of 56 assessments that we have done and evaluations, this is again statistics which I just discovered when preparing for this. The number could be higher because I just came back from a country where we are doing an assessment. Out of 56 countries worldwide, only 13 seem to have systems in place where they can monitor. And these 13 are both developing and developed countries. But the majority of them, 25, 18 of them, do not have any systems in place. And when you talk to them or you make recommendations that they need to come up with systems, two things we hear most of the times. One, they don't have the resources to put in there, or two, the compromise is to go for the self-regulation, emphasizing that maybe they could have a self-regulatory mechanism to be put in place. But the point here is I think there is still a challenge out there in terms of appreciation of the connection, whether there is really a connection between the NGO and the vulnerability to terrorist financing. I think the whole thing is there is need for more evidence to persuade them, to convince them that it's worth spending the meager resources for most of the countries to spend on monitoring the NGOs, other than maybe encouraging them to develop proper rules and processes for strengthening their governance mechanisms, or even transparency, to ensure that the monies that they are receiving from overseas or domestically is accounted for. But that has nothing to do with terrorism, but it has to do with the whole issue of corporate accountability. I think I'll stop here.
Good afternoon. It's a pleasure to follow that excellent talk. And my perspective on this issue comes from several angles. Firstly, I've spent a lot of time in my career developing U.S. NGOs whose purpose was to benefit counterpart organizations in developing countries. I've also spent time working on behalf of bar associations with the FATF process. And then in also my private practice, I've done a lot of compliance and enforcement work for a variety of organizations. So I want to talk briefly on three themes. One is some observations about Special Recommendation 8 of FATF. I want to look a little bit at the U.S. voluntary best practices for U.S.-based charities, and then finally talk about how terrorist financing can be effectively targeted. We've heard already about the core of Special Recommendation 8, so I won't go further into that. But one thing that the best practices of Special Recommendation 8 talk about is that the measures adopted should not disrupt or discourage legitimate charitable activities. Instead, they're supposed to promote transparency and build better confidence. Now, despite that, my experience and the experience of practitioners that deal with transnational philanthropy, because I've been in a lot of meetings in the last 30 years with these practitioners, and that is that already national laws make it difficult to do transnational philanthropy. An example is when I set up U.S. organizations and people want to make contributions, most of my experience has been with the Caribbean. I find that U.S. individuals that want to make donations, they're usually making small donations, $100 or $1,000 to their former school in the Caribbean, or to art organizations that I have set up, or in one case I set up a multi-purpose organization for Belize, of the Belizean diaspora. And what they want is they want a charitable deduction, because that's what Americans get when Americans make a contribution to a U.S. charity. But to do that is very difficult, because they can't just give it directly to the foreign charity. They've got to run it, they've got to funnel it through the U.S. charity, and then they can't directly designate what the purpose is, or that it's going for a certain purpose, because if they do that, they risk that when the IRS audits, they will lose their deduction. So in many cases, they simply just don't make the contribution. And I found that despite, for instance, the goal of the U.S. government in many cases, including the Bush administration just in the last year, had a heads of government meeting with the Caribbean leaders, and one of the three main themes of that meeting was to empower the Caribbean diaspora in North America to be more active in philanthropy, partly because the U.S. government doesn't have the funds, or doesn't want to spend the funds on normal aid. I mean, that is a point that we already heard. So there's a couple of different ways that this could be done. The U.S. has negotiated some income tax treaties, especially one with Mexico, where the U.S. has said, if an American citizen makes a donation to a Mexican charity, that person will receive a deduction in the U.S., although it quite hasn't worked out, because so far the IRS hasn't recognized the Mexican charities. But this also brings another question, and that is, should either the international community or developed governments do something, have a carrot for developing countries to do more in the area of terrorist financing with respect to charitable organizations, because it is partly a problem of capacity. I throw that out, whether there should be benefits. The other area is that with respect to Special Recommendation 8, is the issue to take effective action against NPOs that either are exploited by or actively support terrorists. And we've heard that the normal way is criminal prosecution, but that Sue Eckert talked about how, because that wasn't working as a temporary measure, the international community developed this process of listing and delisting. And that's basically what the U.S. has used. However, the one case where the U.S. has tried to prosecute a charitable organization didn't really go that well, and that was the case of the Holy Land Foundation for Relief and Development. There was after many years of first having delisted the organization, they were then prosecuted. They were defended by a very small firm out of Albuquerque, and the firm had to get a license from OFAC to even represent them, and even then they had to get approval from the court to have experts, and they easily did not have as many resources as the prosecution. Nevertheless, and there were a lot of difficult issues having to do with use of Israeli intelligence, which had to be translated, and there was a lot of information that was classified, and the defense was disadvantaged. Nevertheless, at the end of the day, one person was acquitted, and there was a hung jury for the other 4. There still is going to possibly be, there still will be a retrial, but one can say that the normal mechanism of prosecution hasn't worked well in that case. Okay, let me now turn to the U.S. anti-terrorism financial guidelines for charities. It was first issued in November 2002. They reissued them in December 2005 after some dialogue with the private sector. And there's still a lot of debate about the first of all, whether the guidelines are really voluntary, because many charities have said, my God, we're going to get prosecuted if we don't follow these guidelines, and so we really think they're not voluntary, they're mandatory. A lot of the guidelines have the same purpose as Special Recommendation 8, I think they do track in a lot of ways. The U.S. also has a matrix, which I think is very useful. It's called a risk matrix for what charities who are giving, who are either raising or giving funds abroad should look for, and those I think are very useful. Okay, because I don't want to take much more than a few minutes, I'm going to turn now to really my sort of concluding remarks, which concern how do we target terrorist financing more effectively. And clearly, I think there is a need for continued scrutiny. Despite the fact that there are issues about the extent of the misuse, and there needs to be, for instance, some criteria on monitoring processes, so that, for instance, high-risk area charities with considerable donations can be asked to monitor foreign aid projects more closely and to report to authorities. That this type of oversight, it won't work for all NGOs. Some will not have the resources to do it, and some will not pose a great danger simply by the amounts of money that they're dealing with. For instance, most of the charities that I've set up are all volunteer, and they only deal with, they usually don't even deal with more than 100,000 a year. And the processes I work out, they have to have agreements, and there has to be accountability. But even that takes a lot of time explaining to the foreign charities why we have to have all this accountability and why we have to do it every year, and why we have to have an audit trail for all the expenditure of the monies that we give them. There have been problems which the prior panels discussed in terms of the listing process, especially the case of Al-Barakat, which you've already heard about. That case was especially problematical because it involved Somalia, which was also designated, and eventually, when Al-Barakat was delisted, there wasn't much publicity given to it, and it has caused a lot of problems both in Somalia, and I think more importantly, that in some other cases, like the Qadi case, have caused the problems that we've already heard about, that now the international community is no longer willing to make permanent this temporary process of listing unless the international community can do a better job of making sure that there's due process both in the listing and the delisting. And here, we've seen, for instance, a number of reports by conferences that had been organized, for instance, last year by Norway on the UN process. We've also, we're still waiting for the Court of Appeals decision in El Barakat. There's the Qadi case that is still pending, and I think Alyson may be saying some more about this, so I won't. So instead, let me conclude by saying that, I think, especially having participated in the FATF process, that what is especially important is that to the extent we want these, the listing to have legitimacy and to be sustainable, we're going to have to, at the very beginning, involve the entire world. I mean, if the FATF recommendations are going to have universal following, then you can't have 34 officials from law enforcement countries making the rules. I mean, I see this when I participate right now in the process. I mean, FATF, when I told them in 2002 that, look, the private sector hasn't participated in the framing of the problem, they haven't participated in the policies, the proposed policies, you've given us 2 chances to have a hearing, but then you're going to go behind closed doors without any record, and you're going to make policies for the entire world, which you expect the entire private sector and the governments to adhere to. And guess what? There are a lot of problems. And only if FATF and international organizations and governments make policies that are that meet the same transparency and governance that they expect the charities to meet, will those policies have legitimacy themselves, and will they be sustainable? And finally, only if FATF, international organizations, and governments make policies that are cost-effective, will those policies be sustainable. For any of you who want, I've skipped a lot of slides just in the because of time, and I'm be happy to make those available, but I want to turn the panel over now to Alyson.
Thank you very much. It's a great honor to be here today. Thank you very much for the invitation. It's also a great relief to be here today after the best efforts of the FAA and American Airlines. Anyway, I hope I can share with you some thoughts from over the pond, the big one that is, not Lake Erie, on some of the issues that we've discussed today. A little bit on charities and the non-profit sector, but more generally on sanctions and some of the cases which are going through the European courts just now. Now, if the US doesn't have a single brain, the EU certainly doesn't either. I'm not sure that it's a case that more heads are better than one. It's certainly complex. We have the member states, still 27 now, which are the legislators in some cases, sometimes jointly with the European Parliament, which is elected. The Commission where I work is more or less the executive, but we also have a role as a partial legislature. We make legislative proposals for the implementation of sanctions. And it's certainly not an overall intuitively simple process. Now, talking about hard and soft power, I think the EU often instinctively characterizes itself as the #1 proponent of soft power. It likes spending money around the world, and that's often seen as the primary way to bring about policy change. But I think without realizing it, it has also become a major actor in the sanctions field over the last few years. Its common foreign and security policy has evolved from being a very loose framework for cooperation when everybody agreed to being something much more structured with the Maastricht Treaty. And we also set out our objectives in the Maastricht Treaty, which are very great and perhaps idealistic ones: to safeguard the common values, fundamental interests, independence and integrity of the EU in conformity with the principles of the UN Charter, to strengthen security of the EU, to preserve peace and strengthen international security, promote international cooperation, democracy, rule of law, respect for human rights, all good stuff. So human rights have sometimes been a reason for imposing sanctions. You could take the case of Burma or Zimbabwe, or indeed terrorism itself. I think, as Jeff was saying, terrorism is a violation of human rights, and preventing it can be a good reason for action. Within the EU framework, all 27 member states have to agree unanimously on a new sanctions regime before it can be implemented. And then we in the Commission make a proposal for how to implement the shared aspects of that, which is basically the trade and financial aspects of it. And that can be adopted on the basis of a majority. And then when it comes to updating lists on the basis of decisions by one of the sanctions committees in the UN or one of the EU autonomous regimes, then that can be done by an accelerated, expedited procedure just within the Commission. We have now, I think, about 25 different sanctions regimes in total, 16 of which involve asset freezing or financial sanctions, and 9 of those come from a Security Council resolution or resolutions. 7 are autonomous EU ones. I'd like to highlight our latest and greatest one, which was against the breakaway Republic of Anjouan in the Comoros Islands. We followed the example of the AU, which for the first time ever, I think, adopted targeted sanctions in respect of the leadership of that regime. And we thought that was great, and we would implement financial sanctions and a travel ban too. And an invasion happened, I think, days after our legislation was published. So that didn't stop the military action being taken. Now, the EU has tried to develop and extend, analyse its own practice to some extent, and we've agreed a number of papers in recent years which can all be found on our website, the Commission, and are quite useful sources for researchers. We agreed a paper on basic principles, setting out the cases where the EU would impose sanctions, sanctions guidelines, which include standard legal texts and legal considerations, and then best practices, which go some way towards giving guidance to governments and to the private sector on how best to implement sanctions. And then, of course, EU member states have been very heavily involved in all the various smart sanctions processes in recent years, the Interlaken, Stockholm, Bonn, Berlin processes, and the recent Watston Institute project. So EU sanctions policy and practice is certainly maturing, but I would hesitate to say it's fully grown up. I'd like to talk a little bit about the case law which we have, a little bit about the implications of the new treaty, which, fingers crossed, I think everyone would agree, should enter into force early next year, and then conclude by a few remarks on where the EU is with respect to implementation of Special Recommendation 8. So the EU autonomous terrorist list has given rise to one line of case law. And the leading case is OMPI, which is the French acronym of the People's Mujahideen of Iran. It is perhaps the simplest legal analysis in that you're looking at something which is entirely within the EU legal framework. Although there is Security Council Resolution 1373, there's no list there, and therefore the EU has a choice as to who it chooses to designate as terrorists. So that means you don't get into the issue of the supremacy of the UN Charter. Now, the first judgment in this was handed down by the Court of First Instance. There are 2 courts at the European level in December 2006. And the court chose to exercise full judicial review because it said the EU wasn't just implementing a Security Council resolution where it had no discretion. It did have discretion. it analysed quite extensively what the human rights framework are, and I think it's important to underline the balanced approach that the court took there. I mean, it said that rights in general apply, but recognised the special limitations of the context, which could mean, for example, that although normally prior notification is required if you're going to interfere with somebody's property rights, in this case it wasn't. It would be enough to give people procedural rights afterwards. Obviously that would deprive the measures of their effectiveness. Also, somebody who is targeted had to have the ability to make their case heard by the decision maker. But again, that also implies that they need to know what the case against them is. At the same time, the court recognised that because of the nature of evidence that was used, and because of the context, there could be justifications for limitations on that exact right. You do not need to disclose something if to do so would jeopardise public security. However, the target must receive enough specific reasons, specific to that person, to enable them to exercise their procedural rights, and also, importantly, to enable the court to exercise its role as supervisor of the implementation of the regime. So, finding that even with the limitations, these core procedural rights were not met, it annulled the regulation as far as it concerned OMPI. There had, meanwhile, been a subsequent decision to continue listing OMPI, so that they continue to be subject to financial sanctions for now, but they are appealing again. So the court of first instance has applied these same standards in a number of cases now, Al-Aqsa, Chisolm, and also the PKK. And it just a few days ago came out with the same result as regards the PKK. So the EU has changed its procedures as a result of that December 2006 ruling. So I'd highlight some of the following elements in the changes. There's a new working party established, which includes representatives of all 27 member states and the EU institutions. Its job is to examine proposals for listings and delisting. So that process existed before, but it's been formalised now. Member states or third states can submit proposals which have to include all relevant information, circulated to the delegations in advance of the meeting, and deliberations are confidential, but that these terms of reference are public now. A statement of reasons is given to each listed person, which is meant to enable them to understand the reasons for their listing and to allow judicial review of the decision. It explains how the criteria for listing are met and includes the nature of the terrorist acts which are meant to have been committed or planned and by which national authority they have been investigated or prosecuted. Each person is notified of their listing and of the options which are open to them, whether to seek exemptions or to seek delisting or submit evidence to the decision maker, and also to challenge their listing in the EU courts. And this list is frequently reviewed. It's reviewed in its entirety every 6 months, and there can also be periodic reviews in between times if evidence is submitted. Any delisting proposals are considered on an expedited basis. So far, 10 persons and 5 groups have been delisted since 2002. Now, there will be a further case brought by OMPI. The judgment hasn't come out yet, but that will examine how far these new procedures meet the standards which the court will require. So that will be an important case for us to see if we're doing the right thing now. Okay, the UN Al-Qaida and Taliban regime, the two leading cases, as I think we've heard, are Qadi and Yusuf/al-Barakat. Now, the Court of First Instance in the first level decisions upheld the EU laws which imposed sanctions on these two entities. It was basically looking at the legal framework, including international legal framework, and accepted that the EU had very limited discretion to go against something which the Security Council had decided under Chapter 7. It did, however, recognise a limited exception for human rights insofar as they were part of jus cogens, the non-derogable part of human rights. And it concluded that these, the applicants' rights to property, to a fair hearing and to an effective remedy, insofar as they were infringed, did not constitute jus cogens. Just a sort of interesting footnote here, the Hassan and Nayadi judgments from July 2006, there was a little added nuance to this analysis, which is that EU member states are bound to act in compliance with human rights when acting as members of the UN Security Council. And when they when a delisting proposal is put before them, they as member states must ensure human rights are respected insofar as they present that to the Security Council. Now, January 2008, we had the Maduro opinion, which recommended that these laws be overturned on the basis, basically, of human rights, and in particular, the absence of independent review in the UN system. Now, it would not be appropriate for me, speaking as a representative of the EU, to speculate as to the outcome of that ruling. Of course, the EU will comply with whatever the court hands down. We simply don't know which way the court is going to go in what is an extremely important, clearly, and extremely complex case with the interrelationship of community law, EU law, human rights law, and UN, international law generally. So, watch this space. The Treaty of Lisbon, assuming it enters into force, will bring about a number of changes. It'll cover the current gap as regards EU internal terrorists, which currently, because EU sanctions are linked to foreign policy, purely internal groups such as ETA and the IRA cannot be subject to asset freezes. They can only be designated as terrorists, but with fewer consequences. And it requires necessary legal safeguards to be implemented. Now, we don't fully know what these necessary legal safeguards are until we get the court judgments, but we should find out soon. And judicial review is also extended to this little bit of foreign policy, which involves listing people. So that's a small but a significant exception to the idea that foreign policy decisions are immune from judicial review in the EU system. There's also a little change in the institutional balance because the European Parliament will gain power as co-legislator as regards the framework for asset freezes on internal terrorists. So, an interesting time to be working in the sanctions team. Now, it's very hard to add to the very good points that have been made by Stuart and Bruce as regards the difficulties of dealing with the non-profit sector. Certainly within the EU, we have enormous diversity of member states, of legal forms that are used for non-profits, of their objectives, their activities, and also the scale of it. In some of our newer member states, we're really trying to get the sector off the ground because it didn't really exist under communism, or not in the form that we imagine today. In other member states, the non-profit sector makes up more than 10% of GDP. So it's an enormously diverse and complicated set of facts that we're dealing with. Now, the Commission has prepared a communication in 2005, the end of 2005, which proposes a way forward based upon the Special Recommendation 8. And it suggested that there should be appropriate oversight mechanisms. There should be registration of NPOs insofar as they enjoy public benefits, whether that's tax exemptions or the ability to receive grants or collect funds from the public. And it proposed also a sort of more voluntary code of conduct as the first step for regulation. Now, there is an enormous lack of facts. The Commission has commissioned 2 studies into the sector across the EU, and even they are finding difficulty in getting the right people. Some member states, there is not anything like a single authority which is responsible for the non-profit sector. So it's difficult to even get the first kind of information. I think also the Commission would like to piggyback off existing forms of registration so much as they exist already, such as for the tax system, and also to put this in a wider framework of combating all kinds of financial abuse of the sector. It does seem that donor fraud is the biggest problem in this sector as far as we can tell. And there is a strong incentive for the public, for the sector, to have appropriate mechanisms in place to prevent that and terrorist financing, as appropriate in the context. So the Commission is continuing to work on this and enter into dialogue with the sector, experts, academics, and all that, but it's proving more complex than anyone expected. Okay, thank you very much.
Okay. Thank you. There's been a lot of criticism of the UN sanctions regime, and listening to Jeff earlier, I thought, well, there's an answer to this, that actually rather than listing individuals based on submissions by member states, we should just check whether people have a sense of humour or not, whether they can laugh. But I started thinking about that and then thought, well, hang on a minute, I'm British. And British sense of humour is pretty obscure at the best of times, and some people think it's a bit of an oxymoron even to say British sense of humour. So I thought, well, maybe that doesn't work. So perhaps we should turn to rock and roll. I think that probably is quite a good criterion to use.
I mean, either of these criteria favour the Germans.
Yeah, I know. I love the Germans. But just as there's criticism of the sanctions regime, so is there criticism of any regulation or regime that sets out to deal with international terrorism. International terrorism is quite obviously, by definition, a slippery customer, a difficult thing to deal with. And if you look at the FATF regulations, as we are now, they are, of course, aspirational. Like all counterterrorism strategies, they're aspirational rather than practical. And so when you try and turn them into sort of practical action, you find that they're not only difficult to implement, they're probably impossible to implement. And I don't believe that any country in the world is in fact compliant with FATF. I'm talking about the 9 special recommendations now. And also what they tend to do is channel activity down particular areas because countries feel, well, that's what they should concentrate on because of the dictates of FATF rather than because of the dictates of the terrorists. Now, I think if you look at 8, Special Recommendation 8, which is what we've been asked to do, it starts by saying countries should review the adequacy of laws and regulations that relate to entities that can be abused for the financing of terrorism. Well, as Nikos was pointing out earlier, almost any entity can be abused for terrorist financing. And why it goes on to pick out non-profit organizations are particularly vulnerable. It says that, but where's the evidence of that? I don't know what evidence there is to say non-profit organizations are particularly vulnerable. They're certainly vulnerable, but are they particularly vulnerable? Are they particularly used by terrorists to fund terrorist acts? I'm not sure that we've seen a lot of evidence to suggest that. So already when you look at SR8, you think, well, hang on a minute, what's all this about? And then it says, well, countries should ensure they cannot be misused by terrorist organizations posing as legitimate entities. Well, how would charities do that? I mean, obviously the burden would be up to charities. There would be a sort of know your donor regime. How would you do that? In Muslim charities, for example, I mean, the zakat, the duty to give alms, is a basic duty of Islam. And also, one of the aspects of that basic duty is that you should do so privately, without trumpeting the fact that you're a very generous person. And indeed, many other non-Muslim countries have that same sort of cultural attitude towards charity. Indeed, here in the United States, although you see many plaques saying this is the so-and-so, so-and-so, so-and-so building, or whatever, nonetheless, a vast amount of charity is given privately and quietly. So this onus on charities to check their donors, when charities have far less resources than banks and other financial institutions, which are obliged to know their customers and complain about doing so, I think is, again, a very difficult thing to introduce. The second recommendation under SR8 is countries should ensure that non-profit organizations cannot be misused to exploit legitimate entities as conduits for terrorist financing, including for the purpose of escaping asset freezing measures. Well, that means that charities shouldn't be used as sort of innocent intermediaries for terrorist financing. Well, that's fine. But if you're a terrorist financing an operation through a global network of charities, then you have to decide which bits of that charity you're going to try and sanction, which bit of that charity you're going to try and control. And if you're worried about the escaping the asset freeze measure, it suggests that you're going to freeze the assets of that particular branch or that particular charity, which of course will make it incredibly difficult for that charity to continue in operation. We have a case in Pakistan, some of you may be familiar with the case of the Al-Rashid Trust, which was very active in Afghanistan under the Taliban, was quite clearly doing a lot to the benefit of the Taliban regime, even if its intention wasn't just to promote the Taliban. And it was put on our 1267 list, and it remains there. And now the Al-Rashid Trust, which is not operating in Afghanistan, but operates very, very widely in Pakistan, is challenging that through the court, saying, well, why are we on this list? And indeed, it's very difficult for the Pakistani government to defend this case. The Al-Rashid Trust does a huge amount of work. In fact, well, now very much less because, of course, all its assets are frozen and most of its offices are closed. But it did a hell of a lot. And indeed, during the earthquake in 2005, you remember, it was particularly able to distribute blankets and food and so on to the affected areas in the Pakistan side of the line of control in Kashmir, because it had those connections with the groups that operated up there, and it could get people in. And indeed, the UNHCR, I believe, also used it before it was discovered that it was a listed entity. So these things are not at all straightforward. And I think that one of the problems we're facing at the moment in the sanctions regime is whether when you list a charity or not-for-profit organization, you automatically list all its branches wherever they are, or whether you should just specify which ones should be sanctioned. And that's a very, very important issue. I'm conscious of the time, so I'm going to go on immediately to the third subparagraph of SR8, which says, to conceal or obscure the clandestine diversion of funds intended for legitimate purposes to terrorist organizations, which means that charities take funds under false pretenses, essentially, and send them off to finance terrorism. Well, there again, there's a difficulty there, of course, in spotting that, because if the whole purpose is to conceal it, then spotting it requires quite a lot of effort. And it also raises another problem that we're facing at the moment of what does it mean to have a listing? Does it mean a listing is restricted to the particular name that you list? Or if the name changes by a couple of letters, but it's the same address with the same directors and so on, is that a new entity? Is that a different entity, or is it the sanctioned entity? And these issues are also quite unclear in the way that we apply the sanctions regime. And for lawyers and others, of course, they're very interesting questions to try and pin down, because if you say, yeah, well, that's clearly a breach of the intention of the sanctions regime, well, okay, so how do you modify the sanctions regime to take account of it? And the last point I would like to make on the issue of charities and NPOs is a point that was made earlier this afternoon about the enormous good that they do and the enormous contribution they make to the distribution of aid. Without them, many, many governments couldn't deliver their aid programs. And we have a real risk if you shut down the activities of those charities, that all those people they're helping suddenly start thinking, what's going on here? This is further evidence of discrimination against us, our co-religionists, or whatever they may be. And it's not true, as Jeff said, that they all hate us, whoever us is. They don't all hate you, let's say. I'm talking to Jeff directly. They don't. All the surveys show that, in fact, even radical extremists in other parts of the world value some basic freedoms. They're not against laughter, they're not against freedoms, they're not against all these other good things that we say we stand up to protect. What they are against is what they see as a discrimination and abuse of them as a group, as a minority, or as a majority, or whatever. And a lot of that is perceived, it's not real, but that is the issue that we have to address, is the perception. We have to get all that vast majority of people in the world to work with us to counter the activities of a very, very small, tiny, tiny group of people who want to destroy things.
Thank you very much to all our speakers. That was fascinating to me. We have some time for questions, or if you have, I noticed you all writing, if you have comments on each other's or questions for each other, we could let you start off, but otherwise we'll just have questions from the floor.
Well, first, if anybody asks questions from the floor, be sure you wait for the mic, because I'm receiving emails from people that are watching this on the web, and they're saying they're having difficulty hearing the questions, and they would appreciate it if people use mics.
Thank you.
The one comment I would make is on what Richard just said, and that is that a lot of times when we are listing charities that are in Muslim countries, then at the same time they're also not getting official government assistance, And some of those places like Pakistan or Palestine have 20, 30% unemployment, and it becomes a recruiting tool for more terrorist acts. And so I think we risk the possibility that we're not stopping terrorism, but to the contrary, we risk making the environment that is more conducive to the very people that we want to stop, who are able to use those conditions to recruit to do more terrorist activities.
Agree. Brittany. Yes.
I do want to. I would like to be sanguine about the prospect that we are all agreed on some basic things, because one of the things that give me comfort is if there was not as much disinformation out there. So I look at disinformation as political warfare, and there's been a lot of disinformation I've heard today, and I don't blame any of the people who have said it, because it is out there. It's out there in the blogosphere, and the notion, for example, that we have no empirical evidence that charities abuse or terrorists abuse charities. I think what is the definitive account of how Al-Qaida got its money before 9/11 is the 9/11 special monograph on terrorist financing, and it said, contrary to popular belief, bin Laden did not have the benefit of his family money. Instead, all the money that Al-Qaida needed in order to buy peace with the Sudanese government and then with the Afghanistan government came from like-minded Gulf charities. And so I think that would be what I would ask a court to take judicial notice of if I were litigating this case. And so when I hear people doubt whether or not that's the case, it makes me think that there's disinformation. Al-Barakat was the one entity that was publicized in the U.S. where we de-designated some of the Al-Barakat entities, which, if anything, suggests that we do have a system in place, rather than the opposite, to challenge a designation. And when it comes to U.S. Charities in the U.S. that we have taken action against, there have been 8 or 9 that have been officially designated. The batting average of the U.S. in successfully defending those designations under our executive order is 1,000. It's charity for charity, and that's completely unrelated to the Holy Land Foundation criminal prosecution, which has a different standard. And I will also say that to say that the only charity that the U.S. government has ever charged with anything related to terrorist financing was limited to the Holy Land Foundation ignores a lot of what we have been doing, which is at least a dozen cases around the country which are publicized and are there for all the world to see, complete with open courtrooms and juries and everything else. And so it's amazing to me that nobody, as we are sitting here today, there's so much disinformation out there. And I guess my question is, and this is really directed for both Richard and Alyson, do you sense in Europe that there is this aggressive effort to thwart soft power tools, as there seems to be in the United States?
I don't think I can really accept the characterization of this as being misinformation and disinformation. I think that, as Richard was saying, where is the evidence that the non-profit sector is particularly vulnerable? Yes, it has been documented, and I certainly accept that in a number of cases, charities have been used, or there have been legitimate grounds for suspecting charities of involvement in one way or another in terrorist financing or a whole heap of other abuses. But to say that the sector is particularly vulnerable, you need a baseline to be able to do that.
Right. I guess.
And it's a comparative analysis.
Yeah.
Compared to what?
Yeah.
And what's the percentage as a whole of the whole? And there, it's true, we do not have the facts to be able to draw any conclusions as yet. The facts are missing to take, to see this in proportion.
Right. I guess the question I have is FATF acts on the basis of an empirical perception, and I think well, maybe it's not empirical, but are we challenging the very existence of the FATF finding? Is that, to me, that indicates that we are suggesting that FATF was wrong and we should go away. When I deal with the charitable sector, what I say is, you guys ought to be happy that we're trying to clean out the unscrupulous members of your industry, because there will be greater spoils for you once you all come up to standards. And we end up. I mean, it's very much like the banks reacted in the 1980s when we started requiring them to bolster their compliance. Now, 20 years later, they've gone with the program. I see the very same thing going on with Charities right now.
I think that, obviously you raise a very fair point, but it's not the charities that are giving money to Al-Qaida groups now. It's individuals, and it was always individuals. It's donors. They may do it through some sort of NPO, or they may do it directly, and now they do it directly. And in Saudi Arabia, where you have, and the Gulf generally, where you have a lot of donors who still give money to Taliban or Al-Qaida groups or whatever, or try to, and the governments there are very conscious of that and do try very hard to do something about it. In Saudi Arabia, for example, the charity laws that they passed, though they are yet to be fully implemented, are extremely good and effective in outline. It's just very, very difficult for them to fit that within the cultural ambiance of Saudi Arabia. But nonetheless, it is now very difficult to send money abroad for charitable purposes without going through a government agency. That's what you have to do. And if you talked about Osama bin Laden in Sudan, you have to remember the times, pre-9/11 times. When Osama bin Laden was in Sudan, it was a transition from him being funded directly by the Saudi government, by the Pakistan government, by the American government as well, indirectly. There was a very, very different agenda. Sudan was a transitional phase. It was before the East Africa bombings. Then, he went to Afghanistan, and things changed a lot. But, one should be careful, I think. And I'm not saying that the FATF, the 9 special recommendations are wrong. What I'm saying is they need to be kept under constant review. You need to think, are they useful for the purpose for which they were designed?
Yeah. Go ahead.
Just a quick response. I think from our perspective, certainly in terms of dealing with countries that are outside the sphere that you are mentioning, because there's FATF standards apply to all countries, all jurisdictions. Certainly all our member countries within the World Bank, they are required to comply because we have recognized the standards. But I think it's the responding to the questions that are raised. You go to a country and they say, but what is our risk? And particularly nowadays when we go to evaluate these countries, we have made it a point to meet with the intelligence, intelligence agencies in these jurisdictions, precisely because police normally wouldn't know what's happening. So we normally meet the intelligence because they would be able to even tell us off the record, yes, see, this is what is happening in this country. Like I went to one jurisdiction which helped one Western country. I want to mention the Western country, but they helped them to arrest Al-Qaida suspects. And it has nothing to do with charities. It had to do with this Western country saying to the small developing country jurisdiction, Al-Qaida suspects are coming to your country, monitor them at an appropriate time, arrest them. And they did that, they cooperated. That was about 5-6 years ago. But I think the question they always raise is, we have never been subject to domestic or international terrorism, so why are you saying that our sector? But here's the evidence. This is what our sector is doing in terms of AIDS, in terms of poverty reduction, in terms of agriculture, basic stuff, healthcare, building private hospitals. I think that's the question. But where it resonates, I think where if you meet even NGOs, those that are both of self-regulatory organizations and NGOs themselves, what resonates with them is the issue of transparency, issues of donor fraud. That is one of the reasons why some of them have undertaken radical reforms. And when you ask them, have you looked at issues of terrorist finance? They said, no, our issue is donors. Donors are actually saying we can't give you money unless you are able to produce audited accounts and the like. So I think it's a question of how do you approach it, and maybe even attain the goal of making sure that if they have proper accounting processes, they're able to monitor money which is coming in.
Yeah, just comment on the 100% record of listing charitable organizations. I mean, the problem is when you're trying to challenge a listing, I mean, first of all, a lawyer has to get a license. The organization that they're representing has their money frozen. When you try to find out the reason for the listing, you usually have a few sentences, and when you try to find out more, you're told classified information. And so, I mean, one can say that the process of trying to challenge a listing, whether you do it administratively or through court, is very questionable in terms of due process.
But I would say that to the extent you argue that it's obvious that those are unfair, you're basically arguing against law, because every court that has viewed those factors have found them to suffice for American constitutional standards. So basically, you're making a lawless argument. You're saying that
You scoundrel.
the courts be damned, it's unfair.
No, it's true that U.S. courts have tended to side with, so far, the U.S. government, because of national security reasons. But I still think that, many people have cited the questionable due process of the entire system, and it's also reflected now in why the international community is reassessing the process of listing and delisting.
I think it's important that we make the point that we are not denigrating or suggesting that all Muslim charities are corrupt, because no one is making that allegation or making that case. So that's point number one. But having said that, there is certainly compelling evidence that some Islamic charities have been corrupted, either from within or through donations where the person was thinking the money was going to a legitimate humanitarian cause when it was funneled off to finance terrorist activity. And why do I say that? A review of the consolidated list, which Richard is in charge of, there are approximately 40 charities that the international community has designated as being related to Al-Qaida or the Taliban. On the U.S. OFAC list, there are now close to 50 charities that have been designated and linked to Al-Qaida, the Taliban, and other terrorist groups. So why is there particular concern? Well, that's one of the reasons. The other obvious reason is that if you read any of bin Laden's statements, public statements, recorded statements, he himself has stated that Muslims have a religious duty to use zakat. He's taken this very precious principle, one of the pillars of Islam, and perverted it. He said that zakat should be used to finance the jihad, the killing of innocents. And so that's what he's imploring his followers to do. So I think there is reason for concern. And then having, and apparently the UN consolidated list has recognized that, as has the U.S. list. And then what I hear you saying is particularly troublesome, because I hear Bruce saying, be careful not to designate them because you may offend somebody, and he may then take up arms against the U.S. I hear Stuart saying, don't regulate them because they have limited assets and limited resources, and we don't want them spending money on regulations and reporting requirements. And so what are we supposed to do? There's a problem, and what are we supposed to do?
I think what we're supposed to do is really concentrate on the individuals. What the people you want to stop financing terrorism are individuals. Sure, you want to make it difficult for them to do that through charities, but I think that the designations of charities in the early days have really cut that off. Well, not cut it off completely, but really shut it down quite a lot. And I think that when you designate a charity, it's not the charity itself which is doing the bad thing, it's the people who are directing the charity. And that's why I think that designations of charities must be backed up by the designations of the individuals who are directing their activities.
Sometimes you can't separate it. Sometimes the individuals and the charity are one and the same. The board of directors, the people that are directing and leading the charity are also corrupt, again, in some cases.
Well, that of course may be true that you can't easily separate the two, but it's much easier to identify and track the individual than a charity which has a brass plate, I don't know, in the Cayman Islands or something, and can just quickly change its name and go elsewhere. So I do feel that while it's not wrong, of course, to highlight and alert states to the fact that this particular entity is being used to finance terrorism, the key thing is to identify the individuals behind it.
Okay.
Maybe
Oh,
Thank you.
we have a question over here. That's maybe our last one, I think.
Can I just
Barrett?
clarify a little bit of this, because I do have one point of agreement with Jeff that there is misinformation out there about charities and terrorism, but not necessarily in that direction. What I have found is that there is a lot of information about charities, papers published on the internet, and you check the references and they don't exist, or they make the opposite point that when they argue. I think there is some clearing of the air that is necessary. All charities, I think there is evidence, all kinds of charities can be and have been abused from all religions, not only Islamic ones. What there is an issue with is the particular emphasis with Islamic ones when there hasn't been conviction in the United States or other places with respect to the issues we're discussing here. Now, it may be that, so I think that when there isn't any evidence, then we just do not designate and destroy what good work they do and help us de-escalate conflicts in parts of the world. If we have intelligence that is non-shareable or producible in court, that there may be links to terrorism, then we follow the money, we monitor, and we prevent terrorism, rather than shutting down a window of opportunity to prevent terrorism. So you can have a win-win situation there again. So you don't have to designate someone you suspect of terrorism to stop terrorism. You can be more effective doing things otherwise. Now, the 9/11 Commission has also pointed out that the way 3 Islamic charities were treated in the US, in the Midwest, was rather problematic. And they did have access to intelligence that we here in this room do not have. For them to make that argument so strongly, that there are some fundamental issues of process and fairness and effectiveness, then I think that this is something that needs to be looked at. The other point with respect to the FATF is that I think that FATF does not help its credibility when it follows too closely and uncritically and reiterates things that have been proven in court not to be correct. For example, in its 2005 or 2006 typologist report, it cited Barakat by name, despite its practice of sanitizing examples that it uses. It cited the Massachusetts Barakat case as a case of terrorism finance when there was not even a charge of terrorism finance in that case, or anywhere for that matter. And yes, it is true that the US removed people associated with Barakat from lists, but it was only after the governments of Canada and Sweden and others had to press very hard to do that. And the owner of Barakat, many parts of Barakat, to this day, despite lack of charges and evidence against them, are still on those lists. Check them. On the EU list.
Mohammed Hussein is convicted. You know that.
Jamali is not.
Well, but Mohammed, you say that nobody's convicted. He was convicted.
He was convicted of not having a license to transfer money from one part of the world to another. That was not a terrorism charge.
Right, but you say no convictions.
I said no terrorism convictions.
There are no terrorism convictions.
So, not with Barakat.
Right.
Not with Barakat. But so, for FATF, to name someone who hasn't been even charged with terrorism finance as an example of good practice, to me, is case laundering. You take a bad case and you turn it into a guideline for the rest of the world. That doesn't help the legitimacy of FATF. That's the point. The same thing last week with how the Holy Land Foundation case was presented. When we have a court decision, it is not helpful for FATF and for what FATF wishes to accomplish to mention that as a case that, despite the verdict, we consider it as terrorism finance case. And it wasn't even charged. The Holy Land Foundation was not even charged of supporting Hamas, but providing funds to zakat committees that were not designated, and that these zakat committees were somehow controlled by Hamas, even though the USAID and other organizations also contributed to the same zakat committees. And it is also interesting to point out that the former US ambassador to the region was one of the witnesses in this case on behalf
Who was that? Abington? He was never the ambassador.
Well, he was in the past.
Ambassador.
At any rate, but those are important facts that you know, when there are disputes, when there are heated debates, when there are controversies, I don't think that a body like the VIIIth does itself any good, or the following of its recommendations around the world, when it mentions things controversial as facts, and they're not.
Thank you. Clearly, this is an area where there is a great deal to debate, and I have found it fascinating, and I thank all of our speakers and our other participants here. We are running behind, so the break that was scheduled for the end of this session is going to be shortened to 10 minutes. Is that going to work? 10 minutes, and then start back up with the next session. Thank you very much.